Hello and welcome to the Minimum Competence episode for Friday, June 20th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, EU leniency for Apple and Meta, Trump's hold on California's National Guard, and his third TikTok ban delay, despite no clear legal basis. Let's remember, who holds the devil, let him hold him well. He hardly will be caught a second time, and read today's legal news. On this day in legal history, June 20th, 2002, the U.S. Supreme Court delivered a landmark ruling in Atkins v. Virginia, holding that the execution of individuals with intellectual disabilities violates the Eighth Amendment's prohibition on cruel and unusual punishment. The case centered on Daryl Renard Atkins, who was convicted of abduction, armed robbery, and capital murder in Virginia. During the penalty phase of his trial, defense attorneys presented evidence that Atkins had an IQ of 59 and functioned at the level of a child. Despite this, he was sentenced to death. In a 6-3 decision, the court reversed its earlier stance from Penry v. Lynaugh from 1989, which had allowed such executions. Justice John Paul Stevens, writing for the majority, emphasized the, quote, evolving standards of decency in American society, noting that a growing number of states had barred the death penalty for individuals with intellectual disabilities. The court recognized that such defendants are at a heightened risk of wrongful execution due to difficulties in assisting their own defense and the possibility of false confessions. The decision did not establish a national standard for determining intellectual disability, leaving that to the states, but it set a constitutional floor by barring executions in these cases outright. Atkins significantly reshaped the legal landscape of capital punishment, prompting states to revise death penalty statutes and sentencing procedures. The ruling reinforced the importance of individualized sentencing and safeguarded vulnerable populations from the most severe penalties. It also underscored the role of psychological and scientific evidence in constitutional interpretation. While not without criticism, Atkins remains a cornerstone of Eighth Amendment jurisprudence and a key moment in the court's ongoing reevaluation of capital punishment. Technology giants Apple and Meta are currently facing possible penalties under the EU's Digital Markets Act, or DMA, but the European Commission has decided not to immediately fine them, even if they don't fully comply by the deadline next week. In April, both companies were fined €500 million for Apple and €200 million for Meta, and given 60 days ending June 26th to align their practices with DMA requirements. Apple was penalized for preventing app developers from directing users to alternatives outside the platform, infringing DMA fairness rules. Meta was fined for its pay or consent system, which required users to either pay for an ad-free experience or agree to extensive personal data use. The Commission saw this as limiting user choice. Since November of 2024, Meta has offered a new, lower data personalized advertising model, which remains under Commission review. The current situation involves ongoing dialogue. Any future fines will depend on the outcome of that review and will be imposed only after detailed assessments rather than automatically once the deadline passes. These April fines were deliberately modest, reflecting the short duration of noncompliance and signaling the EU's priority on achieving compliance over punishment, marking a softer approach compared to previous, harsher antitrust actions. The situation also plays into broader economic tensions. EU leaders have threatened digital advertising taxes in response to recent U.S. tariffs, while a U.S. trade report criticized EU digital regulation as a trade barrier. A U.S. appeals court has temporarily allowed Donald Trump to retain control over California's National Guard, despite a legal challenge from California Governor Gavin Newsom. The decision from the 9th U.S. Circuit Court of Appeals pauses an earlier ruling by Judge Charles Breyer, who had found Trump unlawfully federalized the Guard without meeting statutory requirements or adequately coordinating with Newsom. The court stated Trump likely acted within his authority and that even if coordination with the governor was insufficient, Newsom lacked the power to override a presidential order. Still, the court left open the possibility of further challenges under laws barring federal troops from engaging in domestic law enforcement. Newsom plans to pursue his challenge, arguing Trump is misusing military force against civilians. The case stems from Trump's deployment of 4,000 National Guard troops and 700 U.S. Marines to Los Angeles earlier in June to suppress protests tied to his immigration policies, actions Newsom said infringed on state sovereignty and legal limits on military involvement in civilian matters. The Trump administration argued troops were protecting federal property, not performing law enforcement. During a hearing, the appellate judges examined whether courts can assess a president's decision to federalize troops under a law allowing such moves only during invasion, rebellion, or when civilian enforcement fails. The court found the last condition may have applied given protest-related violence. However, it rejected the Justice Department's claim that such presidential decisions are beyond judicial review. The Insurrection Act and related federalization authority are central to this case. The act allows a president to take control of a state's National Guard in limited situations, such as rebellion or when laws can't be enforced by normal means. This case illustrates both the expansive view of executive power and the judiciary's role in checking it, even amid claims of national emergency. President Trump has once again extended the deadline for TikTok to be sold to a U.S. owner, granting a third 90-day reprieve through an executive order, despite lacking a clear legal basis for the extensions. The move allows TikTok to continue operating in the U.S. while negotiations persist to transfer ownership from China-based ByteDance to an American entity. The previous extension fell through when China withdrew from talks following Trump's new tariffs. This delay has not yet faced a court challenge, even though the original ban, passed by Congress and upheld by the Supreme Court, briefly took effect in January. Trump's personal popularity on the platform, where he has more than 15 million followers, adds a political twist to the ongoing negotiations. TikTok praised the decision and emphasized its importance to 170 million users and 7.5 million U.S. businesses. Despite concerns from national security officials and lawmakers like Senator Mark Warner, who accused the administration of ignoring known risks, the repeated extensions suggest a softening of resolve. Analysts describe the situation as a recurring political maneuver with no clear endpoint, likening it to the endless debates over the debt ceiling. Meanwhile, TikTok continues to roll out new features and expand its services, including AI tools debuted in Cannes, signaling confidence in its long-term U.S. presence. Tech giants Apple, Google, and Oracle remain engaged with TikTok, reassured that the administration won't penalize them under current law. Public opinion has shifted, with fewer Americans now supporting a ban compared to 2023. Concerns remain over data privacy, but many citizens are unsure or opposed to banning the app outright. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here on Monday, and until then, note, we like to close out the week of shows with a featured musical piece that will make these Friday episodes seem especially long. We hope you'll stick it out and enjoy the featured piece, but if music, and specifically classical music, isn't your bag, we get it. Our mouth sounds unrelated to the week's closing music ends here. This week's closing theme is by Johann Sebastian Bach. Bach, one of the most influential composers in Western music history, composed the Goldberg Variations in 1741. Originally written for harpsichord, the work consists of an aria, followed by 30 variations, returning to the aria at the end of a da capo structure. It was likely commissioned by Count Hermann Karl von Kaiserlingt, a Russian diplomat suffering from insomnia who wanted music to soothe his sleepless nights, though this origin story is debated. The aria, which opens and closes the piece, is a gentle, saraband-like melody in G major. Unlike other variation sets built on melodies, Bach bases the Goldberg Variations on the aria's bass line and harmonic structure. This allows for extraordinary variety in texture, form, and mood across the variations while keeping a consistent foundation. The aria itself is simple and elegant, consisting of two balanced halves, each repeated. Its serene tone contrasts with the technical brilliance and contrapuntal complexity found in many of the following variations. Yet the aria's emotional restraint and clarity set the tone for the entire cycle. Over the centuries, the Goldberg Variations have come to be seen as a pinnacle of keyboard composition. The aria, both opening and closing the work, serves as a kind of spiritual bookend, calm, contemplative, and timeless. Performers often approach it with reverence, as a moment of stillness and symmetry amid musical adventure. Without further ado, Johann Sebastian Bach's Goldberg Variations, the aria. Enjoy.